Our next case is C-Spine Ortho versus Progressive. We'll give everyone just a second to get settled. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone, which you may waive, and I see that we've added a warning bell when you have 2 minutes left of your time, so you can listen for that as well. And then you may retain some time for rebuttal, but we ask that you keep track of that time yourself, and you may begin. You ready? You good? Right. Okay, you may begin when you're ready. Thank you.
Absolutely. Thank you, Madam Chief Justice, and may it please the Court. My name is Caitlin Kramer. I represent Progressive in this appeal from the Court of Appeals. I'll waive the free fire. I welcome the Court's questions because I do think the opinion from the Court of Appeals is somewhat messy and hard to navigate, so I appreciate any questions as we walk through this together. You have asked us to address, I think, a simple question: whether a plaintiff has standing and is a real party in interest if, before filing a cause of action, it had assigned its rights to that cause of action to third parties, but after filing the cause of action, the third parties assigned those rights back to it. I think that demands a simple answer as well, and my answer would be no, that there cannot be standing, or a party cannot be a real party in interest if it has essentially sold its cause of action to another party before filing suit.
Okay, so I'll take you up on your waiving of the free fire zone. Is it possible for an assignment to take place where you're retaining some of those rights?
I think there could be a situation where there is perhaps some sort of agreement or sale or purchase agreement that does that.
Where the, we'll call the assignor, retains the ability to file suit, they would have standing, they would be a party of interest.
I think so, because I come back to the right to contract, and C-Spine essentially engaged in that right to contract here, but assigned all of its interests away. Perhaps if a sale agreement was drafted differently, that could be a situation, but here they assigned all of those interests, they sold them.
I'm trying to get at it, for all those other cases, we make a decision in this case and say, no, when an assignment, full assignment has taken place, there's no standing, there's no rights. But that can be contracted differently going forward. The response to a ruling like that could be that could be contracted.
I think it could, because I want to respect that we do have that right to contract, and I don't think that's ever really been abrogated by this court. But in this specific situation, C-Spine totally divested itself of those interests. The sale agreement is very clear that they had no power to settle, collect, solicit accounts in any way.
And then talk to me about the counter assignment. So once that took place, do they step back in or no?
Well, that's the question. The counter assignment, the way we usually look at this in no fault is a plaintiff, an injured person who is assigned away to a medical provider like C-Spine or others, and may revoke that assignment later. I think the next case on your docket addresses that specifically. In that case law is already held, the Court of Appeals has repeatedly held, that you cannot essentially gain additional rights via that counter assignment. So they are fixed. If you decide as a panel to recognize that counter assignment and allow it to confer standing, we still cannot let it be a time machine back to day one when the complaint was filed. C-Spine would only retain any interest that the medical financiers had on the day of that counter assignment, giving them the right to sue or giving them the right to prosecute this case.
So if C-Spine had filed on January 1st and then realized, we had divested ourselves of all these rights with this assignment, we want to do a counter assignment back, and that was 4 days later, and they did that. Are they good to move forward?
They would be good with whatever rights the medical financiers had on those 4 days later. This goes to essentially the one-year back rule of the No-Fault Act, truly. And to me, that's a failure of the opinion from the Court of Appeals in that it did not address the one-year back rule at all. In ruling essentially, one, that MCL 500.3112 gives C-spine standing almost automatically despite the assignments and counter assignments, and then secondly, turning and saying, well, if they did have a counter assignment that would give them standing regardless, I don't think both can be true. And if the second is true, that the counter assignment gave them standing, it cannot work as a retroactive going back to day one of filing the complaint. We then have to look at the one-year back rule, and this opinion does not do that. So I think both myself and Brother Counsel might agree that if you do look at the counter assignments, you do need to essentially answer that hole in the opinion about the one-year back rule in the application.
Can you tell me, what's your understanding of, is there a difference between standing and real party and interest? And what is it, and when does it arise?
I believe the case law dictates that they are separate doctrines or separate concepts, but they do greatly overlap. And I think in this case, they are pretty much one and the same.
Okay, so, I mean, if we look at like the Cannon Township case where there was an assignment before suit was filed, right? And, or I'm sorry, there wasn't an assignment, that was the problem, that the township filed and obtained the assignment after suit was filed, almost a year after it was filed. And the Court of Appeals there addressed it, and some other courts have, as the real party and interest issue. Would your contention be that Cannon Township sort of missed the boat and that, in fact, the township should have been dismissed because they didn't have standing? The Court of Appeals viewed it as real party and interest that could be corrected as long as it's corrected before a final judgment, right? And they are separate doctrines. Sometimes I get your point that they may collapse, but the standing is at the time initiating suit. And why are we not, shouldn't think of real party and interest being that the judgment, as long, the judgment can't enter as long as it's not entered against the real party and interest?
I think firstly, there are a couple differences with Cannon Township. Cannon Township, there were two parties that were the assignors, excuse me. So Cannon Township had received an assignment from one party, I believe it's the Marks family, but had not received an assignment from another party. So Cannon Township to me is distinguishable because it at least had that assignment from one party, at least had some real interest from that party.
Well, but I think in that case it was the one party was actually their insurer who was the one who needed to give it to the township, and that they were the ones who hadn't done it prior to suit and corrected that. And the Court of Appeals seemed to say, look, as long as you can correct the real party and interest, and I think it's done in any number of cases, right? You have a party who passes away, you have substitution, joinder, making sure that why am I wrong in viewing real party and interest as that sort of almost like the bookend of standing, of saying the judgment can't enter unless and until it can only enter against the real party and interest?
I guess my answer to that would be it places, well, one, I think still Cannon Township, there still at least was one party starting the suit that had standing. Here, C-Spine did not have any, it had assigned away everything. If C-Spine and perhaps the medical financiers had sued jointly, maybe there's a different argument. But secondly, I think an analysis of real party and interest in that way places a burden on the defendant to suss out those issues, essentially. And I think that's what happened here in a way. If you review the procedural history, we had to file multiple motions to even discover this issue. Right. And essentially, there could have been, the risk is that there would have been a final judgment without that correction, without that analysis of who was actually the real party, if not for the discovery efforts that we had to engage in.
Isn't that fairly typical discovery in no fault when I used to practice in it? I mean, that's question one or two.
It has become fairly, because of the assignments.
Right,
yes.
Assignments, any type of thing. What is it in the particular assignment that you think assigns away the statutory standing that C-Spine otherwise would have had?
Specifically in their agreement, I believe it's page 106 of our appendix, it states there's a power of attorney given to the buyers, to the medical financiers. There's the absolute servicing of the accounts that is given to the buyers. And there is this specific language that they shall not collect, they cannot recover, they cannot negotiate, they cannot do anything when it comes to the money for these accounts. I think that's a divesting of the cause of action. And I would look at the covenant case that seems like it now was decades ago that we decided covenant, had to deal with covenant in the no-fault context, but it does define a claim for a medical provider as the right to payment. Under the terms of that agreement, they didn't have a right to payment. MedFinance had that right to payment, or the medical factoring companies. And to me, this goes back to the MCL 500.3112 issue, and the Court of Appeals essentially pinning, I think, all of their analysis on that MCL 500.3112 gives C-Spine a direct cause of action, so we need not even look at the counter assignments. They kind of did both things in their opinion, and that, to me, is inherently contradictory. But if we look at this analysis from covenant, where this direct cause of action really begins to sprout, so to speak, until the legislature codifies it, that still defined the cause of action by that claim, by that right to payment. And under the terms of these sale agreements and what was conferred, there was no right to payment. There was a sale, there was money received for that, and then the medical financiers retained any and all interest in those servicing accounts.
Would you agree there was still a beneficial interest on the part of C-Spine? I understand your argument, they gave it away, but
I would not,
just struggling
Judge.
with the statute clearly says they have a direct cause of action, and they still obviously have an interest in making sure they get paid.
I would not, Judge, because they received payment, or Justice Welch, I would not, because they received the payment already. They essentially have no interest retained in that agreement. They already received money for these accounts that they sold, so no, I don't believe there is a beneficial interest. And the assignment, our case law on assignments strictly states that the C-Spine essentially divested itself of any and all interest, not just a real interest, not just a beneficial interest, but any and all. I also think, Justice Kavanaugh, I think you brought up joinder, and the opinion from the Court of Appeals does talk about joinder as this cure-all. I mentioned the discovery issues. You know them well from your practice. I think joinder also places a significant burden on the defendants to figure out who these parties are. And joinder cannot cure a defect that existed day one on filing the complaint either. The joinder rules are meant to bring in other parties with a real interest, not confer real interest or standing on a party that did not have one.
Well, it might save the lawsuit, but it may not, it may still impact the one you're back. Is
Yes,
your position,
absolutely.
right? Like, the suit can maintain, they can substitute in or join a proper party, but then we have a Miller retroactivity sort of issue of whether or not.
Absolutely. I think that at the end of the day, if this court chooses to adopt that approach of, well, the real party and interest can evolve, we can add, we can subtract, we still have to, in the no-fault context, definitely consider the one-year back rule and how to apply that. I do want to reserve a couple minutes for rebuttal, so I do see my time is coming to an end, but I'm happy to answer any more questions.
Counsel, I just have one more. In your, I'm sure, very broad litigation experience, do you have litigation with factoring companies?
We do, yes.
Okay. So as a practical matter, they file lawsuits to collect from the insurance company?
There have been some that do, yes.
Okay, thank you.
And thank you for the broad litigation experience compliment. I appreciate it. Thank you.
Thank you.
Good morning, Justices. My name is Matthew Payne, and I'm here representing C-Spine Orthopedics, the plaintiff appellee in this case. This is actually my first time here, but it's going to be my second time as well in just a few minutes. And that's not because I have some, appellate practice. That's absolutely not it. The reason is I have significant experience in trial court in these cases, hundreds at a time, both in favor of plaintiffs and providers. And one thing that this court is probably going to be surprised to hear is that while factoring companies may have sued in some instances, I have yet to see one instance ever where a PIP insurer has ended up paying twice because of an assignment, regardless of whether that assignment is by a provider to a factoring company or by a patient to a provider. In 40 years since the inception of the No-Fault Act, there was an acknowledgement of a dual nature of the claims by a patient and its provider under the No-Fault Act for the same benefits. We had no issues whatsoever dealing with anything that arose by ourselves. It wasn't until this court issued its opinion in Covenant that required providers to get assignments, to obtain standing, to pursue their own rights, that we started seeing some issues. And we got a litany of them. There were tons that I would consider to be pure gamesmanship. These are efforts to avoid payment of otherwise compensable benefits merely by leveraging procedure. So really what I want to focus on in my free fire time here is the fact that the only legitimate interest the insurance company has in this case and in Wallace is to avoid duplicative payment. And simply by applying Michigan law, we can do that. The Revised Judicature Act expressly states that both the assignor, well, not so much expressly, but it defines the real party in interest to include the assignor and the assignee. It doesn't require that the claim be brought by both parties who have an interest. The court rules have a mechanism for joinder where any defendant in the state is potentially concerned about duplicative payment, that it can protect itself through joinder. And then we get to the No-Fault Act, which is even more liberal in favor of these insurers. Not only does it discharge their liability when they pay the correct person, all they have to do is believe they're paying the correct person and their liability is discharged. And that's ultimately my point today. There's no possible benefit here to ruling in any way that eliminates the dual nature regardless of these assignments. It would only serve to divest and deprive Michigan citizens of benefits for which they could still be liable to the provider. So ultimately, the insurance companies need not even investigate. Sure, they're more than welcome to ask in discovery whether there has been any assignment, but they don't even need to. They don't need to worry about it because if they don't have notice, MCL 500.3112 expressly states that their liability is discharged where they pay the person they believe is entitled to the benefits. They're more than welcome to find out. They're happy to join if they need to protect their interests, which again, as a matter of practical fact, has never happened. But they have.
I appreciate your extensive experience with these and sharing all of this. I think it's very helpful. I guess I want to take a step back to just the basics here, which is whether it's in these cases or other cases. And we have requirements for filing lawsuits, and one is standing. And one is that you have to be a party of interest. So that's our starting point. And if C-Spine didn't have standing to file the lawsuit, we can't just say, well, but it all works its way out in the end, and the statute protects it, and there's no reason that the insurance company has to be raising these things. But
I appreciate you focusing me because I do get sometimes in the weeds after having dealt with this so many times. My brief on this issue and the argument that the Court of Appeals adopted is the exact answer to that question. The Revised Judicature Act 600.1405 defines a real party as interest as someone who has entered into a contract for the benefit of another and states that that party need not join that contracting party to file litigation. And that's exactly what we have here. C-Spine could not have stayed in business without giving some sort of interest in its accounts receivable. These providers, these small businesses in Michigan can't operate waiting 2 years through litigation, paying attorneys, not getting any payment up front. They're required some cash up front to even treat their patients.
But could C-Spine or others have drafted an assignment that did not contract away their ability to bring suit? They didn't contract away their standing.
My limited understanding is that they don't have that opportunity because the factoring company is required to be a complete sale.
Well, unless we say that those don't actually do what the parties are saying that they do, right? I understand the realities, right? Especially in the next case, an injured accident victim, is signing these in order to receive treatment, right? And they don't exactly probably have much negotiating power to say that, but it obviously inures to the benefit of the provider if at least it's left open because of the way that the assignment is drafted, such that that either C-Spine or the injured, the accident victim still has the ability and perhaps even the obligation to initiate suit. It's just that if you have assigned away your standing, how are we, to deal with case law that says, an assignor that assigns away standing does not have the ability to bring suit?
The standing exists by having a claim under the No Fault Act after having provided services to the injured person.
And you can't assign that away?
I haven't seen an agreement that references 3112 or otherwise specifically says, I'm giving you all my statutory rights as well.
So you're saying that there's the provisions in the assignments don't actually assign away standing, but the contention is that it's the ability to collect on a claim, to,
And that's the
to
nuance.
prosecute, to do all of the thing, the broad language. We all know what these things look like. That doesn't include standing.
Yes and no. The assignment can be read not to transfer away the 3112 provider standing under the No Fault Act. It can be read that way. Even if it's not read that way, we go back to the Revised Judicature Act in 600-1405, where it says when you do make that transfer, you are still a real party in interest and you may sue in your own name. They accrued the claim. They had standing at some point. That standing, I would argue, was not transferred away. But even if it was, the legislature has already told us how to deal with that procedurally.
Counsel, is there a reason it would be difficult to get, I guess I'll call it, an assignment back from the factoring companies before filing suit? I mean, I'm just wondering, from a process standpoint, is that complicated?
Yes, because many of these providers use multiple factoring companies, and they don't even, it's not like one patient, they're done with the treatment, here's all of that entire bill. They assign away every single treatment that they did and on any particular date of service. They could have done 12 different things, right? So they need to find out to whom it was transferred and when it was transferred and how to get that back. But I want to extrapolate on that question a little bit. Yes, it is very procedurally complicated to do that. It was nice that it was done in this case, but it ended up being moot. So I do want to make a very specific distinction between counter assignments and rescissions of assignments. Because in my cases that I handle at the trial court level when this comes up, I get rescissions. So if a PIP insurer and its insured can mutually agree through contract that there was never any coverage, we've seen that all over the place in appellate authority in this state. If they can do that, why can't the provider and the factoring company do the same thing and rescind the agreement such that even if there were a transfer of standing, it, as a matter of law, never actually happened?
Right, of course, that's not something we've decided yet.
Right.
Well, but we have decided in Wilmore Moody, right, that the fact that actually sort of it was the insurer arguing that they can rescind the contract, and, we said, well, that doesn't, that's a legal doctrine, but that doesn't change the reality, right? It's not a DeLorean time machine, I believe, is what the line, I mean, you don't go back and say, like, this alternate reality that actually you did have standing when you filed suit.
Yes, I completely, so yes, a rescission, even effectuated by a court of equitable jurisdiction, does not operate to actually change the past. What it does do is change the contractual obligations between those parties, and that's all we need here for standing and real party and interest between, again, the insurance company is not even a party to that transaction. Their only legitimate interest is not paying twice. If a provider files suit and gets a rescission of any assignment to a factoring company, how could that insurance company ever have to pay twice? Regardless of 3145, regardless of the timing, regardless even of whether it's a rescission or a counter assignment, ultimately, if the other party that's not a party to the litigation waives any sort of entitlement, it could never be deemed a real party in interest. And the provider plaintiff would be the only real party interest. Yes, it doesn't necessarily operate to change the past, but it changes the contractual obligations that remedies this situation entirely. For the only reason that we're even here today, which again is to avoid duplicative payment that doesn't ever happen.
I understand you referenced the RJA as really sort of saying that the assignment doesn't actually assign away standing, but I'm struggling with how a provision of the RJA that doesn't in fact even mention assignments or govern assignments or how to construe them or that, but governs real party and interest is supposed to be this tool through which we look at a particular assignment. Can you help me
Of course.
get there?
Very simply put, and I'll quote, I'm sorry, I think I said 4, it's 24, it's MCL 600-2041. A party with whom or in whose name a contract has been made for the benefit of another. So in this case, that's C-Spine assigning its benefits, the accounts receivable, to a factoring company. C-Spine is a company in whose name a contract has been made for the benefit of another, and the statute goes on, may sue in his own name without joining with him the party for whose benefit the action was brought. That is right on the head for this particular instance. C-Spine signed a contract for the benefit of factoring companies to secure enough money so that it could even exist and provide PIP insurance medical coverage to Michigan residents, right? It did that, and the legislature has said in that context, you can sue in your own name.
Would it be, the plaintiff have to be C-Spine for the benefit of factoring company?
No. That statute doesn't require that. It specifically says you may sue in your own name. And we can talk all about the practical effect of this as well. Who do you really want to be a party to the case? The factoring company? What are their initial disclosures going to look like? I bought this, here you go, pay me? C-Spine isn't benefited by being the plaintiff in this action. It's the best way to get value for legitimate PIP claims. That's all it is.
So is this, do we need an exception for, in the no-fault context?
An exception for what?
Well, an exception for assignments saying that as long as they have standing, right? Not anybody can sue, but whether it's the provider or the injured person, as long as they have statutory standing to sue, we're going to say that they can, that they can sue as long as the real party in interest, the judgment enters against the real party in interest, because there is, in every other assignment issue, the assignor does not have standing to initiate the suit. Straight up.
So I wouldn't necessarily classify it as an exception. It's just plain application of the statute, the legislative intent here.
Well, wouldn't that work in the case of every other assignment then, too?
I wouldn't know. I haven't argued those cases. But what I know in this particular case is this is exactly, in my estimation, doing my practice, this is exactly why this provision exists.
Yeah, I mean, I get it. We do have to think of every other case, right, where an assignment, what this would do, unless it is carved out or there is some basis to say why that makes sense here, but that actually doesn't disrupt all of the existing case law that says an assignor has no standing.
So in the particular context of the No Fault Act, I would again go back to 500.3112 and point out the fact that the standing in the context of the No Fault Act is really moot. Again, there isn't even any burden on an insurance company to investigate this, because if they pay without having actual notice, their liability is still discharged as long as they pay the party to whom they believe benefits were owed. So if they don't even know about this transfer, then none of these factoring companies can ever come back and try to sue and obtain duplicative payment, because the insurance company just has to say, my liability is discharged. And it is, I guess to answer your point more directly, that discharged liability isn't limited to anybody claiming under the No Fault Act. It says you don't have to pay these benefits anymore if you pay the party you believe is owed these benefits. So that would be the distinction in the context of the No Fault Act, and why the person would not necessarily need standing when they file the litigation, because ultimately the whole purpose of all of these statutes is to prevent duplicative payment, and the No Fault Act has its very own provision that does that protection itself.
Okay.
Thank you.
Thank you.
Justice Kavanaugh, I think you hit the nail on the head with one of your statements in the last couple minutes. This creates exceptions, loopholes, holes in the statute, holes in the revised Judicature Act that need not exist when we have clear case law already on this issue, and when we have a simple, pragmatic system that already dictates what we are supposed to do with assignments. Your decision would have far-reaching implications, not just in the no-fault world, but elsewhere. And so I would encourage you to not create exceptions, not create loopholes, but let us have this simple system. Secondly, counsel brought up gamesmanship on the part of the insurers. I would encourage you all to review the opinions of multiple Court of Appeals panels that were compelled to follow this decision since it was published, but that specifically and explicitly call out the gamesmanship and the discovery violations that put us into this situation. Multiple panels, I think 4 out of the 5 that reviewed this, expressed their reluctance with following this decision because of that risk of creating exceptions and because it rewarded that gamesmanship and those discovery violations.
Does this exist because even though now under the existing statute there is no need for an assignment, maybe not in the C-Spine context because they're assigning in order to keep their accounts receivable afloat, which I understand, but say in like the next case sort of thing, there is no need for the injured victim to assign to the provider because the provider has a right of suit as well. And I understand that may differ very much from the reality.
Yes.
That a provider is still going to require these in order for somebody to get care, and then we still have this all within this truncated 1 year where we have to figure out who holds what and how to do it. And in some cases, it's an individual victim may have multiple providers, right? Some of which he has an assignment, some of which he doesn't, some of which are ongoing benefits, right, that aren't actually affected by the rules. So, I mean, isn't that a reality in any no-fault case that this is going to, even though 3112 supposedly corrected the covenant issue, these assignments are here to stay?
They still exist, yeah, and I don't see them going away specifically because of the Macosta decision as well, because of the claim preclusion that they can now have if they have an assignment. So I haven't seen a single provider file suit yet that does not have an assignment, does not bring essentially 2 counts, one for a direct cause of action and one based on the assignment. I do see my time is up. I would simply conclude by stating, if we look at 3112, the direct cause of action, it does not confer a right to sue on behalf of a third party or a medical financing company. It encourages these providers to sue for injured people and for patients, and I don't think that language should be altered either. Thank you again.
Thank you. Thank you both. The case will be submitted.